So the info that Ellen gives us will be put on the PARCA, PARCA.org website, and you click on resources. And if you go there right now, her 2 other sessions should be on there. And so I like to have Ellen come around periodically to update us on things and cover anything we may not have covered before. So check on that. But today's will take a little bit till we get it back on, but not too long.
Awesome. And my understanding is we kind of have a mixed group of participants. We have some wonderful parents and caregivers and members of the community from PARCA. And we also have some great professionals who found out about this presentation and have chosen to join us, which I'm thrilled about. So, we'll be able to address both sides of, of special needs planning and management for our disabled loved ones. It'll be fun. So shall I just dive on in, Sue?
Yeah, so if you don't mind starting with the public benefits.
Yep,
So I know for me, I've heard it 100 times and I'm constantly confused.
you got it. Okay, well, let me share my screen. I do have that. And then I'm also going to be looking over at the waiting room and I'll be,
Yes, thank you for that. I appreciate that.
yeah, so I'm doing a few things at once. So I apologize if my
No, no,
brain
no.
snags a little bit.
Better you doing it than I am.
Okay, so today, let me see, let me move this over. All right. Today we're talking about special needs planning. And I have my general slides, but I also have some requests that Sue would like us to dive a little bit deeper into. So I'm happy to do that as well. Just a little bit about me. I'm an estate planning attorney in Palo Alto, and I specialize in special needs planning. I also have a child of my own who has high functioning autism. He's a delight. And then he's 12, and I have a neurotypical 10-year-old who has a twinkle in his eye. So, and then a dog and a cat. So we're a full family. Um, so let's talk about just for a second, when we're doing special needs planning, what are we trying to accomplish? I think it's always good to kind of have this in mind, right? Our main goal is to maximize the quality of life for our disabled loved ones. We're also looking at public benefits, and we will, that's our next slide. But I do want to emphasize, we also want to protect our child from financial predators, sometimes from themselves. We want them to be as independent as possible. Really what we're doing is we're looking at surrogate financial parents for our child when we're gone. That's really what we're trying to set up. And nobody's going to do it as good as a parent, I think. Being a parent myself, I can say that confidently, right? But we're trying to set up a team of people who can step in when you're gone to make sure that your child is well cared for, that the transition is as smooth as possible. And finally, we want to avoid the court system whenever we can. Now, that's not possible when we're looking at conservatorships, but everything that we're talking about today does not involve the court system. I did litigation for 4 long, horrible years. And so I'm very happy to not do anything when it comes to going to court. I'm a weird lawyer that way. Okay, so let's talk about public benefits. That's one of our focuses today. So here is one of my favorite slides. So let me just give an overview of what does this all mean. Okay, so when you're not able to work and support yourself, you need to get the things that other people who can work and support themselves typically receive, which is when you work, you get an income stream, you get your salary, and you get health insurance. Now, my hope is someday we'll join the rest of the developed world and our health insurance will not be linked to our jobs. But right now, that's where a lot of people are. So we need to provide those 2 things to people who are disabled, and due to their disability, they're not able to work and earn substantial gainful employment. All right. So we have our income stream and we have our health insurance. So the top line are the needs-based public benefits. That means you need them because you're poor, because somehow you qualify for them because of either you have low assets or low income. For SSI, they look at both. That's supplemental security income. That's an income stream that you can get up to almost $1,200 a month, and it's to supplement any income you're already receiving. Now it's the most picky one. All right. So if you're earning money, then the SSI is decreased by how much you earn. If you're getting SSDI, it's decreased by that. So it's really meant to supplement any income above and beyond what you're already receiving, up to about $1,200. And if you get even $1 of SSI, you automatically qualify for Medi-Cal, which is California's version of the federal Medicaid system. Now for SSI, you have to have under $2,000 of countable assets. So you really do have to be poor. Now, countable assets doesn't include, a house, certain other things that are exempt, okay? But it does include anything that's in your bank, right? Medi-Cal used to have that $2,000 asset limit. And if you're in a different state, you still have that $2,000 asset limit for Medicaid, for your own Medicaid program. But our state eliminated it at the beginning of 2024, which is awesome and amazing in every way. Okay, but for Medi-Cal, we still have an income limit. And if you go over that income limit, right now it's about $1,700. If you go over that, you have to start paying a share of cost. Now, the rules for share of cost have changed, and I have a slide about that coming up in a few slides. But I do want to point out that Medi-Cal, we're looking at income, and SSI, we're looking at income and assets. Okay, so now we'll go down to the next two rows. So SSDI, Social Security Disability Insurance, that's something that any of us could receive. We paid into the system for a while, and then we became disabled. We can get an income stream based on our work record. Now, if you have a child who's disabled and you worked for a while and then you retired, then your child, oops, somebody's in the waiting room, hold on. Then your child can get half of what you're receiving for your retirement. Okay, that's called CDB benefits, Child Disability Benefits. Your child had to have become disabled before age 22. So they get half of what you're getting. At the same time, you get your full amount. It doesn't decrease your amount. And then when you die, your child gets 3/4 of what you were receiving. And something that's really cool about this is there is no passive income limit and there's no asset limit. Okay, this is entitlement based. The only thing that can interfere with this is if your child is able to work and earns over a certain amount, then that can interfere with their CDB benefits. Other than that, they're going to get it for the rest of their life. And the other super cool thing about CDB benefits is after 2 years and 5 months, because it takes a little while to qualify, you can qualify for Medicare, which most people get by turning 65. But this is for someone who's under 65 and they're disabled. They receive CDB benefits, they can get Medicare. If they're already receiving Medi-Cal, then they can get both. We call them Medi-Medi. It's our kind of cutesy name. All right. So I want to dive in to some of the questions that Sue provided before this. But first, let me just move over to the timeline, because I think one interesting thing is to see, how do public benefits change over time? So this is from a child's perspective. Okay, so on the left, we have the child is born. At age 0, what do they get? Well, in California, every child in California qualifies for Medi-Cal, and they also can qualify for the regional center if they have a developmental disability. All right, so that's why we have those two lines going on. You see the Medi-Cal line and then the regional center line. Okay, so time goes on and on and on, and then the child turns 18. At that point, the child can start receiving SSI benefits, because if they have less than $2,000 of countable assets. Before age 18, your assets, the parent's assets, are deemed to the child. So the child doesn't qualify because it looks like they have more assets, unless you have fewer than $2,000 in assets, which it's difficult to live off of in the Bay Area. Um, and then the child can start receiving a different type of Medi-Cal. Okay, it's not the waiver program, which is what we call the 0 to 18 Medi-Cal. It's a different. There's like 5 or 6 different ways you can qualify for Medi-Cal. Okay, so now time goes on, and now let's say the parent retires. And so I said, the child's maybe 42, 43, whatever. At that point, the child can start receiving child disability benefits. Now, one question Sue had was, does this just automatically happen? The parent receives, starts receiving Social Security, maybe $2,000, $3,000 a month. What happens then? Um, you have to let them know. You have to affirmatively tell them, hey, my kid is getting SSI, but they should be getting CDB benefits instead now. All right. Now, can they get both at the same time? Well, it depends. It depends how much they would receive in CDB benefits. So let's give an example. Let's say the parent's getting $2,000 a month of Social Security, so the child can get $1,000 a month. All right. But SSI covers will supplement up to $1,183 a month. And that's 2024 numbers, so I don't know what it's going to be in 2025. They haven't released those numbers yet. Okay. So what that means is the child will get $1,000 of CDB, and then they can get an extra $183 of SSI. Okay, so they can get both at the same time. But what if the parent is getting $3,000 of Social Security? Okay, then that means half of that is $1,500. And so the child would get $1,500 in CDB benefits, and that's over the $1,183 of SSI benefits. And so the child will not get SSI anymore. They'll only be getting CDB benefits. All right, so whether or not the child gets SSI really depends on how much they're getting for their other income and if there's room to supplement that. Okay. Do you have to apply for Medi-Cal? That was another question that Sue had. It depends, but typically yes. I mean, if you lose, okay, well, so here's an issue. If you lose your SSI and you were receiving Medi-Cal because you were getting SSI, are you going to lose your Medi-Cal? Typically, no. If you lose your SSI because you started getting CDB benefits, or your child started getting it, then your child can get Medi-Cal through a different program. So you have to talk to the Department of Healthcare Services and say, hey, how can my child continue to qualify for Medi-Cal? Because they're not going to qualify. Remember, I said there's like 5 or 6 different ways for them to qualify for Medi-Cal. They'll qualify through a different avenue. Okay. So let me pause. Oh, there's somebody in the waiting room. Let me pause and look to see. I'm going to look in the chat, okay, to see if there's questions there. How do I find the chat? Hold on. Ah, there it is. Good. No, I did see somebody's hand raised. So it's probably the best way if you have questions, you can enter them in the chat, and I'll pause at certain times to answer them. If we have time. Okay, Raul asked, do they include VA disability as income? For SSI purposes, I believe that they do. Any income. I'm 95% sure, so I'll have to go back and double check, but I'm pretty sure if that's what you're asking. Yes, just about any income, because SSI is to supplement any other income you're receiving. Okay, so here's some changes. So now that your mind is chock full of the rules, now I'm going to change it on you a little bit. All right. Okay. So these are changes to SSI. So SSI, it was originally created to say, all right, we're giving you this income stream to cover food, clothing, and shelter. Well, the clothing part was eliminated a while ago. So they don't look at your clothing to see if that's being covered. Food has been really a thorn in people's sides because they've had to say, how is my child paying for food? Here's the issue. If somebody else is paying for their food or their shelter, then their SSI check is decreased by about a third, because the government figures, whoa, you're getting this huge check of almost $1,200 a month. You don't need all of that if somebody else is paying for your food and or housing, right? Yeah, good luck. Good luck living on even 1,200, let alone 800. So, but they will reduce it. Okay, that's called the in-kind support and maintenance. That's the ISM deduction. So here are the two things that have changed with the ISM deduction. Food is no longer counted as part of the ISM deduction. SSI will not look at the child's food to see if somebody else is paying for food. All right. And then the other thing is that for shelter, they're changing the way they compute how much the child needs to pay towards their rent. All right. So if somebody else is paying the child's rent, there's the ISM deduction. If the child is paying their own rent, there's no ISM deduction. But what does that mean, the child paying their own rent? Well, it used to be that the parents, especially if the child was living at the parents' house, the parents would have to look around and get some comps. What is it? How much does it cost to rent a room in this area, right? And then they would kind of estimate that and come up with a number. Well, there were some cases in other states about this very same topic, and those cases concluded it's going to be $334 a month. And so now across the board, that's how much rent is. Okay, so up to $334 a month. You don't have to go over that. If your child's paying $334 a month to you or to whatever provider, that's considered their contribution for rent, and there's no ISM deduction due to rent. Now, there can still be deductions for the other things that ISM covers, which I'm not going into, but like utilities, gas, electricity, other things related to maintaining the house. But for the rent component, $334 a month, which is really good news, because in some areas that you guys live, I'm sure, and where I live, rent can be up to what, $800 a month to rent out a room, $1,000 a month. Now it's just $334. Okay, so then the next change was that the definition of public assistance household, in order to qualify for SSI, your whole household has to be considered, on public benefits. But now it just has to be one other person on public benefits, not everybody else in the household. So that has broadened the number of people who qualify for SSI. Okay, and then the last change to SSI is if Social Security Administration even thought that you got an overpayment, they will stop your checks completely until they sort out how much that overpayment was and they think that it's been paid back, even if they're wrong. I mean, it's prohibitively horrible. It's punishing. So now they're saying, hey, we're only going to reduce your check by 10% as we sort this out. So that is a huge game changer. I've seen that happen a few times under the old rule. It was awful. So now it's much better. Okay, there was one question that came up. What's the difference between Medi-Cal and Medicare, and how does one choose? Okay, so let me just go back to that slide. So Medi-Cal is it's California's version of the federal Medicaid system. And it's really, how do you qualify for it? There's different ways of qualifying for Medi-Cal, and there's different ways of qualifying for Medicare, right? Medicare you qualify for when you turn 65. If you have like advanced stage renal failure, like there's several conditions where you qualify for Medicare, and CDB benefits, then you can qualify for Medicare. Otherwise, it's much easier to qualify for Medi-Cal. The two programs cover different things. Medi-Cal covers long-term nursing home stays. It does a very good job of covering prescription drug costs. Medicare is accepted by more doctors, and it often pays more of the premium. So there's pros and cons to each of them, but it's not like which one do we want to choose. Get on as many as you can, all right? or, one or both. But it just depends on which one do you qualify for. Okay. Now, remember when I was talking about Medi-Cal and I said, if you go over a certain income amount, you have to pay share of cost. So right now, let me say this. There was a law that was passed a couple years ago saying that starting January 1st, 2025, which just passed, all right, um, the law, the law for how Medi-Cal share of cost is going to change. However, they haven't funded that yet. So it's not actually implemented yet. So we're still waiting for the funding for this to take place. But I want to tell you what will take place when we get the funding. All right. So what used to happen, or what's currently happening until they fund it, and you'll see why they need to fund it because it's really, really good news for our Medi-Cal beneficiaries. What used to happen is if you go over even $1 of that income limit, $1,732, they're going to make you pay a share of cost, which is basically a deductible, starting at $600 a month. So from $600 up to your income, your actual income, you have to pay that towards the share of cost. You only get to hold on to $600. I mean, can you believe it? Horrible, 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 horrible. Okay, what they've changed is now if you go over the share of cost, over the $1,732 a month, you only have to pay the overage to Medi-Cal as your share of cost. So anything over $1,732 a month. That makes a lot more sense, right? Yes. Excuse me. So those are those questions. All right, so now I'm going to move along to special needs trust, but I did want to pause for a water break and also see if there's other questions. And I do want to let you know, I have tons of YouTube videos. I have like over 100 videos and I cover all of those topics, excuse me, in depth. So if you have a specific question about like working while receiving SSDI, for example, I have a video on that. All right. So go ahead, not now, but go ahead and take a look at those videos. All right. So what is a special needs trust? Okay, well, first of all, what is a trust? A trust is an agreement between somebody setting it up, the grantor, and somebody managing it, the trustee, for the benefit of the beneficiary. It's like a contract that people are entering into. There's a lot of different types of trusts out there, and most of you should have a revocable living trust to avoid probate. Okay, so when you die, all of your stuff goes to the next generation and avoids the probate court system. So you need a revocable living trust for that. But we're not talking about that today, though I have some videos on it. Instead, we're talking about how should your child receive their inheritance. If your child is receiving those public benefits, SSI and Medi-Cal, then they will need what we call a special needs trust. So this is an irrevocable trust. What does that mean? It can't be changed once the money goes in. And it holds the assets for the benefit of the disabled person. Nobody else gets to benefit from it, just the disabled person who's named, okay? And it doesn't interfere with public benefits. The reason why is because you named somebody else as trustee, not the child themselves. So that somebody else is really the gatekeeper. They get to say yes or no to what the child wants. And because of that, because the child can't reach in and grab the money or they can't change the trust, it's not considered the child's money. And so the assets in the trust are not countable resources. They don't count towards that $2,000 asset limit for SSI. The income generated in the trust doesn't count towards that Medi-Cal income limit. Okay, so it's a really, really great safety net. Your child can be receiving their public benefits, and then they can have this pot of money on the side to pay for anything else that they need. So you might be thinking, well, Ellen, what does anything else mean? I mean, I've heard that these are pretty restrictive. You can only use them for like transportation costs or medical stuff. That's not true. We have a really good case that just came out in 2023. And I want to read it to you because it's just music to my ears, all right? Special needs that encompasses the very broad range of everything else a human being needs in order to live, thrive, and realize his or her potential in life. Isn't that beautiful? So a special needs trust can be used for just about anything. It can be used for a trip to Disneyland. It can be used for, Pokemon cards. Now, the trust officers on this call will know, first you want to do financial projections to make sure that the child's not going to run out of money. You don't want to just, use the money willy-nilly, spend it away, and then they don't have anything. But if you have money in the budget, you can use it for fun things as well. Now, don't use it for gambling or illegal substances. I mean, you get the hint. So that's why it's that's why it's not everything, but it's, anything that really enhances the child's life. Okay, so you should know that there's two different types of special needs trusts. There's a third-party special needs trust and there's a first-party special needs trust. Okay, I got a question. Can I put up the last slide for a second? Joni, that's from you? Okay, so is it this? No, that's the wrong way. This one. Okay, well okay. 5, 4, 3, 2, 1. Okay, so first party special needs trust, third party special needs trust. What's the difference? All right, it really depends on where is the money coming from. So most of you on the call who are parents, you will be setting up a third party special needs trust for your child. Why is that? Because you are the source of the money. You are putting money in for your child. You are the third party in relation to your child. So anybody who is not the child or the child's spouse can put money into a third-party special needs trust, and that's fine. All right? The child themselves cannot put their own money into a third-party special needs trust. Instead, they can put their own money into a first-party special needs trust. A first-party special needs trust holds the first party, the child's own money. So if the child receives a litigation settlement, or if grandma leaves the child money outright, and they go, uh-oh, we have this $100,000. Grandma was trying to be really nice, but oops, this is going to bump my child off of SSI and possibly Medi-Cal. What do I do? The child or you can set up a first-party special needs trust, and the child can put that $100,000 in it. Okay, so the way you choose which type of trust is really functionally, what do you need? Who's going to be putting the money into the trust? So I have a compare and contrast sheet, and again, you will receive the slides afterwards, so you don't have to, take a picture or jot them down. But I want to compare how these trusts function differently. All right. So the third-party special needs trust, anyone can fund the trust except for the child or their spouse. So that can be, an uncle, a friend, I guess a GoFundMe that comes up sometimes. It's a little bit trickier, but grandma, right? People can fund a third-party special needs trust, and anybody can set it up except the disabled person themselves. On the disabled person's death, the trust already says where the money is going to go, and that's where it goes. Now let's compare that to a first-party special needs trust. It's the disabled person's own money that's going in, and the disabled person has to be under age 65 when they put the money into the trust. Now, if there's money in the trust and they turn 65, that's okay. It can remain in the trust, but you can't put additional money in. And that's just by statute. That's just the way the statute was written. I don't know why. Yes, somebody asked, will we have access to the recording? Sue will post the recording on the PARCA website. Okay, who can establish the first party special needs trust? This is more restrictive. So the beneficiary themselves, if they're 18 and over and if they have capacity, they can set up their own first party special needs trust. Otherwise, only a parent, a grandparent, or the guardian or the conservator, and you have to go through court. Auntie can't set up a first party special needs trust. Grandma cannot. It's only that limited number of people. And then the biggest drawback of a first party special needs trust is this Medi-Cal payback. Upon the beneficiary's death, Medi-Cal wants their money back. So anything that Medi-Cal has paid out for services for the beneficiary, starting at the beneficiary age, turning age 55 and up, Medi-Cal gets that money back first. And then any remaining money in the first party special needs trust goes to the remainder beneficiary. So it goes to whoever was listed in the trust. There's no Medi-Cal payback for the third party special needs trust, just for the first party one. Now you'll notice I also put a D4C pooled trust up there. Well, what's that? I thought you said there's two types of trust, Ellen. Well, a pooled trust is kind of it's a you know, a variation on a theme. All right. So basically if you have a first party, if you need a first party special needs trust, but the beneficiary has turned 65, you'll use a pooled trust. Or if you have a very small amount of money to go into a trust and you can't find a trustee, then you can use a pooled trust. A pooled trust is run by a nonprofit organization, and basically they pool together a lot of smaller trusts, and then they have, you know, a case manager and an investment manager kind of overseeing things. All right. So that's the concept. Upon the beneficiary's death, it depends on what the pooled trust agreement says, whether the money goes to that organization or whether it goes to who's named. So you have to look into that. So I think the biggest choice to make in all of the special needs planning is who's going to be that surrogate financial you? Who's going to be the successor trustee? You set up the trust typically as the parent, naming yourself as trustee. But really, we're concerned what happens when you're gone. Who's going to take over managing the money that you're leaving to the special needs trust? So a lot of times you'll look to a family member or a friend, um, but you know, you know as a parent, this is a lot of work, right? Managing your child's care, figuring out all about public benefits, filing tax returns. It's a ton of work, and that's a lot to put on a family member or friend. And also family members and friends, they grow older, they die. So we often recommend a professional. This can be a private fiduciary, it can be a bank or a trust company. There are some nonprofits that act as trustee of special needs trusts. Um, but I think professionals are very good because they know how to do this. Sometimes they charge a percentage, sometimes they charge hourly. So you'll want to look around and do your due diligence. When I'm representing a client, we might talk about who's going to be successor trustee. We might talk about that for like an hour. I mean, it's a big choice and there's a lot of things to consider. So just to know, and I have a video just on, you know, things to think about when you're choosing a successor trustee. So you can look at that. So you might say, hey, that sounds good, Ellen. You know, sure, I'd like to choose a professional, but I don't really know this professional. How do I know that they're going to do the right thing? Or I spoke to somebody at the bank, but they're probably not going to be around in 30 years when the special needs trust is funded. How do I know that the bank is going to do a good job? Or what if the bank decides not to manage special needs trusts anymore, or they give up their trust department entirely, like Bank of America did a while ago, and now they have a trust department again, right? So how do you know? So what I often suggest is naming a trust protector. So this is really the overseer of the special needs trust. This is the person who they get yearly accountings and they can access, you know, bank statements. They can see how the money's being managed. And if things have really gone south, they can remove and replace the trustee with another professional trustee. So I found that this provides flexibility. And I mean, what if the bank or the private fiduciary doesn't like managing this trust? They can resign, and then the trust protector can, you know, can name somebody new. It avoids needing to go to court. And as I mentioned, I hate going to court. So, and I'm sure you do too. So we want to avoid that at all costs. You can also name co-trustees. So you can name a bank as co-trustee with an individual, you know, a sibling or someone else. Sometimes people name an advisory committee. They'll say, hey, I have 4 or 5 family members who want to be involved in advising the trustee on how to manage things. So that's another thing you can do. Okay, so one thing I always recommend to parents to prepare is something called a memo of intent. So this is really, dear successor trustee, here's all the things I think you need to know about my child. And it's especially important
for them. The one I
if you're
really we're really happy.
if your child um, can't communicate their needs, or if maybe they have some mental health challenges and they see things a little bit different than reality. This is super important. Let them know everything about your child. It's like a brain dump. Everything you've learned about your child over many years. Their food allergies, what makes them happy and sad, what your hopes are for housing in the future, what you've already looked into perhaps. Which extended family members do you want them to spend time with? Which extended family members do you not want them to spend time with? So everything that you can think of, that doesn't go into the special needs trust, by the way, because a lot of times parents update these every few years. All right. But it really helps that transition from when the parent's gone and successor trustee takes over. I can tell you, and if anybody on this call is a trust officer and they want to speak up, trust officers, everyone who manages a successor trustee, they love these memos of intent. They're getting into your mind to figure out, how do you really want this money used? Because that's their goal. Their goal is to carry out your wishes. So now I want to make a note. Let me just sip a little water. I want to make a little note of structurally, how should you set up the special needs trust? And I want to let you in on a secret. There's a lot of folks out there who are estate planners who don't know about special needs planning, but they have a drafting software where they can press a little button and it populates a special needs trust within the revocable trust. I think this is malpractice. These attorneys don't know what they're doing. All right. There's what most special needs planners recommend is that you do what's called a standalone special needs trust. So this is a special needs trust that's not within the revocable trust. It stands on its own. All right. We call it a seed trust, SEED. You fund it with like $10. All right. So you don't have to get a tax ID number. You don't have to start filing tax returns, but it's available to be funded. And there's two main reasons why we like standalone special needs trust. The first one is anybody can fund it. If grandma wants to leave money to her grandchild's special needs trust, if it's within the revocable trust, that special needs trust doesn't exist yet. We call it a testamentary special needs trust because it only springs into being on the death of the parent. So other people can't fund your child's special needs trust until it's up and running, until you're gone. But a standalone special needs trust, that trust can be funded at any time. But the second reason, which I think is even more important, is what happens when you die is somebody, typically the successor trustee, needs to send a copy of the special needs trust to Social Security Administration. And they will look over the trust and let you know if there's any problems with it. Now, if you send them your full revocable trust and you say, okay, we'll see Article 6, that's where the special needs trust is. This blows their mind. They have no idea how to handle this. They don't review trusts regularly, right? And the successor trustee language might be in Article 3, while the alternate distribution language might be in Article 10. Sometimes they actually make you cut and paste to say, all right, this is the language that relates to the special needs trust. Don't make them do that. That's why a standalone special needs trust, in my mind, is clearly superior. So what can you put in the special needs trust? All sorts of things. You can put savings, cash. That's the most useful, by the way, cash and investment accounts, any liquid assets, because that's what we're really using to support your child over time. But you can hold a house, a place where the child's living, or even rental property, and the income stream goes into the special needs trust. You can do that as well. You can name special needs trusts as beneficiaries of retirement accounts. And this is actually a good thing under current law. I'm not going to go into it, but if you're curious about this, watch my video about how to fund special needs trust with retirement accounts. Okay. You can name life insurance. You can name a special needs trust as the beneficiary of life insurance. I think this is a really good way, especially if you have a more modest estate. If you don't have a lot of money to leave your child, you can get a life insurance policy and it pays out when you die. And that's really when you need the money. All right. So then the policy can go into the special needs trust. Inheritances, obviously, those go in, settlement. So a lot of things can go into the special needs trust. I do want to mention, for those of us who have, like me, who also have a neurotypical kiddo, or maybe you have a child who's not receiving public benefits and you don't think they'll need it, but they still need some protection. A dynasty trust can be good for them. So this is basically an irrevocable trust. It's kind of similar to a special needs trust in that way, that receives an inheritance, but the beneficiary themselves, if they're pretty savvy with money, they can manage the trust themselves at a certain age. So they can blow it. They can withdraw the money. They can do what they want with it. But if they keep it in there, then it basically, anything that they inherit remains their separate property. It doesn't go to the ex-spouse if they get divorced. So it's very protective. And if there's a creditor's claim against them, it's protected from creditor's claims. And also any money remaining in that trust upon the beneficiary's death goes to their kids free of estate taxes. So there's some really good benefits of leaving money to a dynasty trust. So I just wanted to mention that sometimes we overlook our neurotypical kids. Okay, so next I'm going to dive into ABLE accounts, but let me pause for a second, see if there are questions, and also see, Sue, how much more time do we have for this?
It's up to you.
I love that. Just keep going. Okay, okay. Okay, so I don't see any questions in the chat. So I'll just barrel on along. All right, let's do it. ABLE accounts. I love ABLE accounts, and I think you should too. So what are ABLE accounts? Well, let me give you some background so you can kind of understand just the full benefit and why we needed it in the first place. My understanding is that there was a group of parents of kids with Down syndrome, adult kids, who were working part-time. And those kids wanted to save up their money so they could buy bigger things. But because of that, remember that $2,000 asset limit for SSI and in every other state for Medicaid as well? They had to spend down all their money to below $2,000 every month. That's not fair. We want people to be able to save up their money. This is America, right? So the parents of these kids with Down syndrome went and met with their representative. I believe this was in Virginia. And that representative put together some legislation that had bipartisan support. And it passed. And it was the ABLE account, Achieving a Better Life Experience. So what is this? So this is basically a savings account for a disabled individual that's modeled after a 529 plan, if you're familiar with education savings plans. So what happens is that post-tax money goes into the ABLE account, and it's cash. You don't get to put in, fancy assets. You put in cash, and then it can grow and grow and grow. And then when you withdraw the money for qualified disability expenses, which we'll describe, it's very broad, you don't have to pay any of the capital gains tax. So it's a really nice savings vehicle for somebody who is receiving needs-based public benefits. Or for somebody who's disabled and is not receiving needs-based public benefits, that's okay too. The money in it, just like a special needs trust, does not count towards that $2,000 asset limit or the $1,732 a month income limit. So a few more details about this ABLE account. So I mentioned it's to be used for qualified disability expenses. You only get one. All right, so you have to choose wisely where you set it up. But anyone can make just contributions to an ABLE account, including the beneficiary themselves. So this is different than the special needs trust, where we need two different ones. We need one for other than the disabled person and one for the disabled person. The ABLE account can receive money from the disabled person and from other people. But the main limitation is that you can only put in up to the annual exclusion amount, which this year, it just went up from $18,000 last year to $19,000 a year. So that's the cap of the amount of money you can put in for an ABLE account. So the ABLE account is not meant to supplant a special needs trust. because hopefully you'll be leaving more than $19,000 to your disabled child. And the ABLE account won't be able to receive all of that. Okay. Now the beneficiary can manage the money themselves if they have capacity and if you trust them, or someone else can manage it, which is kind of like a representative payee for Social Security. They're called the authorized legal representative. So they're kind of the stand-in who manages things. Now there are some asset limits here. If the ABLE account grows and grows, and it goes over $100,000, and the beneficiary is receiving SSI, the SSI will be suspended until you can spend it down below 100,000, but the child can continue to receive their Medi-Cal benefits. And then there's the question of what about Medi-Cal reimbursement claims, right? Because remember, with the first party special needs trust, Medi-Cal can get their money back from a first party special needs trust. Well, let me tell you, the ABLE account was set up originally with a Medicaid reimbursement claim. But California and like 4 other states chose to waive their right to the Medi-Cal reimbursement claim. So California does not bring a reimbursement claim. But then California was noticing that people in California were setting up ABLE accounts in other states. And they said, well, how do we incentivize people to set them up just in California? And this is what they came up with. They said, if you are a California resident and you're using a CalABLE account, we won't bring a Medi-Cal reimbursement claim. However, if you're a California resident and you're using an ABLE account in another state that you set up January 1st, 2023 or after, we can bring a Medi-Cal reimbursement claim. So the moral of the story is, if you're a California resident, you really have to use a CalABLE account. All right, so it's like the carrot and the stick. They want you to use the CalABLE account. And by the way, CalABLE account's just about as good as any of the other ABLE accounts. I think it's like a $50 a year charge. You know, there's like several different, I think 7 different platforms of, you know, whether you want to manage things more conservatively or more aggressively, you can choose. Again, it's only cash. So is the child eligible? So they do have to be disabled, but how do you determine if they're disabled? Well, first of all, if they're receiving SSI or SSDI, automatically eligible. Or you can get a self-serving doctor's letter. Now, one other limitation is that they have to have become disabled before age 26, which probably most of the kids involved at PARCA are, but that number is increasing next year. In 2026, that number is increasing to age 46. So you have to become disabled before age 46. And this is really good, especially for the mental health community, where a lot of, you know, mental health challenges, the symptoms start perhaps a little bit later in life. Okay. And I have an example of the self-serving doctor's letter. It's just something that a doctor signs. You keep it at your house. You don't need to submit it anywhere. It's just part of the paper trail. And you know what? Well, I hope nobody from the government is listening. They don't audit these things. They don't check. All right. So SSI is like the strictest, and they check everything. The ABLE account is like on the far other side of the spectrum. They really don't check anything. Medi-Cal somewhere in between. All right. So don't be too concerned about the ABLE account. Your kid should qualify. So what is a qualified disability expense? Again, anything that's incurred as a result of living with a disability and is intended to improve quality of life. Again, that language, quality of life. We love things that improve quality of life because really it's just about everything. All right, now what does this look like for the ABLE programs? In case you're in another state or somebody wants to set up one in another state, the ones in the dark green are states where people, residents of other states can still participate in their state program. So for example, California's in dark green. So if you live in a different state, you can still participate in the California program. So this is important. If you have a child who sets up a CalABLE account and then they move somewhere else, they can still use their CalABLE account. Okay, there's a question, is the $19,000, is that a yearly contribution? Yes. So what that means is once 19,000 goes into the ABLE account, it's capped off. So it's not like you put in 19,000, then you can spend 10,000 and then put in another 10,000. Nope. Once 19,000 goes in, you can't put in anything more for the entire year. Oh, I was just talking about that. Yay. Okay. What about for Medi-Cal? All right. If your child is not receiving SSI, but they are receiving Medi-Cal, the limit for that is super high. It's the same as a 529 limit, which happens to be in California, $529,000. So you can put in a ton of money into an ABLE account. Do you want to? Perhaps, perhaps not. And I have some points on that. But I do want to mention, you can actually put in a little bit more or substantially more if your child's able to work. If your child is working, then they can contribute above and beyond that 19,000. They can contribute their salary up to just over $15,000 a year. Now that's as long as they're not participating in their employer's retirement program. Because this is kind of considered retirement money. All right. So that means when you add the two together, if you have somebody who's working, they're contributing their own money, somebody else is contributing money, you can put in up to over $34,000 a year, which is pretty cool. Gifting, you can make gifts to ABLE accounts. Believe it or not, the ABLE account now, CalABLE has a gifting page where I guess it's like GoFundMe, where you send it out and you can say, hey, you can make gifts to my ABLE account. So go ahead and do that if you're tech savvy. Sue and I, we may not be doing that, where our tech savviness might be a little bit lower than some other people on this call. All right, so I did a little chart here, or a little flow chart. So this is talking about how to make gifts. I think an ABLE account is a great place to make a gift. Okay. If you want to make gifts, let's say you're a grandma and you want to make $5,000 gifts to each of your grandkids. Then you say, all right, I'll just make the gift to the Child Special Needs Trust. Well, I usually don't recommend that, because then you have to get the Special Needs Trust up and running. You have to get a separate tax ID number. You have to file yearly income taxes, and you have to report it to the IRS as a gift. All right. Why do you have to report it? Because it's not considered a completed gift. For that $19,000 annual exclusion to apply, so you can make gifts. Let me back up a little bit. For gift tax purposes, you can make $19,000 gifts to as many people as you want, and you don't have to report it to the IRS. But those gifts have to be what we call completed gifts. That means I make a gift to Sue, she takes it and she says, thank you, and she can go and spend it. A gift to a special needs trust is not considered a completed gift, because by definition, the child can't take the money and then go spend it. Right? So it's not a completed gift. So any gift to a special needs trust must be reported on a gift tax return. Now, that doesn't mean that now you're paying gift taxes. It just means that there's some bean counter at the IRS who's saying, all right, they made $5,000 gift to the special needs trust. They are using up $5,000 of their estate tax exemption, because any dollar of gift tax exemption that you use removes a dollar of estate tax exemption. It's a pain, is what I'm trying to say. Okay. But a gift to an ABLE account does qualify for the annual exclusion. Yay. It's considered a completed gift because it's considered the child's own money, even if somebody else is managing the ABLE account, even if there's an authorized legal representative that's been appointed to manage the ABLE account, it's still a completed gift. For that reason, gifts to ABLE accounts, I think, are superior to gifts to a third-party special needs trust. Now, if you want to make a big gift, right, $100,000, $1 million gift, you got to make it to the third-party special needs trust, because the ABLE account caps off at $19,000. But for smaller gifts, the ABLE account is better. Okay, so I have a chart here. I'm not going to go through it, but you will receive these slides. And you can see I compare and contrast when to use each one of them, what the rules are. So you can go back and refer to this. And then there's one other page for that. Okay, remember I was talking about that ISM deduction? we have another cool way to avoid paying an ISM deduction. One cool way that we talked about earlier, remember that $334 a month payment, that's the most that a child has to pay for their rent, so they don't get the ISM deduction. Well, here's another cool feature. What if that child doesn't have $334 to pay? Well, the ABLE account can pay the rent and there's no ISM deduction because the ABLE account is considered the child's own money. All right, so a child paying their own rent is okay. But what if a third-party special needs trust gives money to an ABLE account and then the ABLE account turns around and pays the rent? Well, surely that can't work, right? I mean, that's really just from the third-party special needs trust. Nope. They don't care where the money came from going into the ABLE account. They just care that it came from the ABLE account to pay for the rent or utilities. No ISM deduction. I know it looks like money laundering, right? You know, like this money, if you have a third-party special needs trust on the left, if you have a third-party special needs trust paying directly for rent, ISM deduction. If you have a third-party special needs trust paying the ABLE account for rent and then the ABLE account turns around and pays the rent, no ISM deduction. It's mind-blowing, but it works. I tell you it works. It's cool. So how do you set up an ABLE account? First, you need a separate savings or checking account at a bank of your choice or credit union. So you get that and you get and it should be a separate one from the SSI account or other accounts. You get the routing and account number. Then you go onto the CalABLE website. That's the only place you can set up an ABLE account. All right. So don't go to Wells Fargo and say, I want to set up an ABLE account. No, you go to Wells Fargo and you say, I need a checking account in the name of the child. Then you go on the CalABLE website and you provide that account number and the routing number and other information about your child, like their social security number, your social security number. They ask for a few other things. And Vestwell runs the CalABLE account. All right. They will set up the CalABLE account for you, and it links to the account that you set up at Wells Fargo. They talk to each other. You can, now how do you get money out of it? You can get a prepaid Visa debit card that you can load up from the ABLE account, and that's how you can spend money from the ABLE account. All right, so you don't have to go to a lawyer to set up a CalABLE account. For the trust, for the first and third party special needs trust, definitely use a lawyer. But for ABLE account, you can do it yourself. Okay, let's see. So what should you do next? It can be really hard when there's this huge brain dump of information that you're like, I'm going to go watch it again. But what are your next steps? Well, I suggest if you have an estate plan, look that over and see how does it compare to the information that you've learned today. Does it need to be updated? Feel free to reach out to our office if you think it does, or if you want to discuss it, we can look over the documents, tell you, what might need to be updated. And also we ask you to share this information with others who might benefit from it. This is what our team looks like. We have a team, there's 3 attorneys and 10 support staff. We're all over the US and even a few in a couple other countries. We're a completely virtual firm, but we're located in Palo Alto. I live in East Palo Alto. So we do have an office in Palo Alto, but a lot of our calls are over Zoom. So we're happy to accommodate virtual meetings. We do estate planning, special needs planning, and trust administration. We typically charge a flat fee. We don't help with public benefits applications. So I'm giving you a lot of information about public benefits, but we charge way too much for you to call us and have one question about applying for SSDI. There are other attorneys out there who help with SSDI appeals. There's a consultant I know who helps with with putting together initial application. So there is information available out there. Okay, so our last slide, you can use your phone to see the QR code and send us an email if you'd like to be added to our mailing list. We do have a once a month mailing list where we send out helpful information to really keep you updated. And if anybody comes in and mentions that they into our office and mentions that they watched this presentation, we will make a $300 donation to PARCA as a thank you. So also feel free to connect to us. I've mentioned we're on YouTube, but like and subscribe. But also, if you like social media, we're very active on Facebook and LinkedIn, and we're developing our Instagram channel as well.